Hello, so this is the AO3 for consent. You need this for an essay. There are so many things you can say for consent. It's a great one to do. It's not an exhaustive list, as I've said before. So first of all, the issue of death. Just be careful in the question if it talks about consent to all offences, because it might just say non-fatal. If it says non-fatal offences, don't talk about death. So if it does just say consent as a defence, is it fit for purpose? I would talk about death, the idea of Diane Pretty saying that it's not okay, you cannot consent to death. It raises the issue of euthanasia. It's illegal in this country. Doctors are there to save lives, not to kill people. The counter argument is, well, surely somebody who is of sound mind should be able to consent to their own death. Particularly Diane Pretty was in a lot of pain. She was going to suffocate, which is a horrible way to die. The issue of sporting activities. So remember, it's allowed if the injury is within the rules of the game. Now, the courts use their common sense here. Every weekend, people play sport and they injure other people. If all those people had to appear in the magistrates' court on a Monday morning, the courts would be overrun with this. So, I mean, there is a distinction between deliberate harm and accidental harm. Sometimes it is difficult to distinguish, but the courts are being sensible. Everyday battery is again another example of where the law is fit for purpose, because every day you bump into people, and again, it would lead to thousands of cases. If we prosecuted someone every time you got on the tube, then the courts would be overrun. Now, the issue of surgical interference. Remember, you can consent to medical treatment if you are Gillick competent. That can be at any age, but strangely, you can only refuse medical treatment when you are 18. We allow, so I'm not sure why there is a distinction there between accepting and refusing. So you can accept it if you're Gillick competent, can't refuse it until you're 18. There's an interesting case in the High Court at the moment about can children consent to puberty blockers. So keep an eye out on the news for that. Valid and true consent. I think the law here is satisfactory. We're saying that even if you consent to the nature of the act, you need to know the quality of the act. And it's quite right that if you have HIV and you knowingly transmit it, or you're reckless about it, you should be classed as a criminal. I think the issue becomes more difficult when you're looking at other sexually transmitted infections. The case of Golding with herpes. Is herpes serious injury? Are we going to start classifying other STIs as serious injury? So there is an issue there. Again, the law is protecting a lot of vulnerable people. Oleg Boja, can you consent through fear? The answer is no, you can't. Consent through fear is not true consent. The law protects young people. So if you have sex with somebody under the age of 13, then it's automatically rape. It is a strict liability offence. We don't care what your mindset was. We don't care about the mens rea. It's just, have you had sex with somebody under 13? Well, if you have, then you are guilty of rape. In the case of G, perhaps this is a little bit unfair, because G was 14 and G thought that the girl was the same age as him, yet now he is a convicted rapist. The case is to do with horseplay and practical jokes. I don't think the courts are doing very much to protect the victims or society by allowing a defence. So the jokes could have gone too far. I mean, in the case of Aitken, he was seriously injured. He had severe burns. He could very easily have died. So the courts are allowing a defence in a potentially dangerous situation. Talked about smacking, so lawful chastisement. Hopley says it can't be done for gratification of rage. It is becoming less acceptable. Scotland have now banned smacking, and that's come into force recently. Harmful sexual activity, there's quite a lot you can say here. The case of Brown, is a dilemma between consenting adults in private and the law not interfering with this, and the law trying to protect people. The courts in the case of Brown were worried about the spread of AIDS, serious injury. They refer to unnatural practices, so hugely kind of linked to the moral element here. It was only a 3-2 decision, which means it's actually quite a weak authority. And in Brown, they took it all the way to the European Court of Human Rights and argued it was against their right to a private life, and the European Court disagreed with them. In the case of Wilson, though, Wilson was Court of Appeal. Wilson, as a Court of Appeal case, should follow the House of Lords precedent, but they managed to distinguish. So they found material factual differences, and they said, hang on a minute, branding someone with a butter knife is not sadomasochism. It's different. It's like a tattoo, and we allow the defence for tattoos. So the courts in Wilson quashed the husband's conviction, even though she needed medical treatment. So it's quite different to the case of Brown. Bree doesn't help the issue of drunken consent, because they said that drunken consent is still consent. Only 1.7% of reported rapes end up in a prosecution. So there is an issue about how drunk do you have to be unable to consent. And then finally, proposed reform is that you can consent to injury, but not to serious injury. So there are lots of things you can talk about in an essay on consent.